so I don't forget. This is LAWS12065, Foundations of Property Law, and today we are covering topic 8, Disposing of Interests in Property, and this is week 10, and it's the 9th of May 2014. Good. Samuel, please. Yep.
I just have a general question, if it's appropriate, in relation to class participation.
Yeah, please. Can you speak up a little bit?
Sure. I don't have a microphone, so I'm relying on my computer.
Okay, that's fine.
Would you be open to considering social media forums for class participation? There is a huge following on the LAWS12065 Facebook page. It's been created specifically by our students, and a lot of the interaction on tutorials and weekly lectures occurs in that forum, probably because it's very readily accessible on our phones. It's an app, and we get notified of new streams and new things. I know we get a daily Moodle digest, but the Facebook forum is just on fire, and a lot of us use that almost on a daily basis.
Look, I wasn't aware of that. If you can send me, yes, if you can send me details about that, and look, what was it specifically you were suggesting or proposing?
The class participation occurs in probably in a multifaceted approach. It occurs both on Moodle and in these interactive sessions, but it probably happens more on Facebook because it's just everybody's on it. Okay, all right. And that's actually occurring for torts, constitutional law. I'm not saying that the lecturers have adopted that as well, but I'm saying that it is used quite intensively, and it's, dare I say, a little bit more open as well, because we speak very freely on that, and we share ideas, and it's as if we're sitting in a classroom.
I think you've got a few connection problems, Samuel. I've just lost your picture. Look, can you please email me what what it is you're suggesting, and just document that. Let me just say generally for everybody, both those attending and those subsequently listening to the recording, my own view, and this should be evident, I think, from the way that I've run things up until now, is that within bounds, I am trying to be reasonably flexible about how I respond to technology and how we move forward. I think all of us involved in the program, there's only a couple of other law schools in the country that have entirely online law programs. And so we all have to appreciate that I think we're in an evolving space, and technology is changing very rapidly. And of course, the Facebook link, I think, has only occurred this year, for example, or it might have been toward the end of last year. We have to adapt and change, and in my view, we have to be responsive to what works best for students in a flexible way, but we have to find a way to make sure that we're achieving what we want to achieve. But if I can find methods to get more of my students involved and participating in the tutorial space or the class space, whatever we wish to describe that, or the participation, let's call it a participation space within the course, because I think that in the online context, as you indicated, Samuel, quite rightly, participation can take place in various ways. And up until now, we've got 2 ways that we've been prepared to recognise for purposes of assessment. That is actually physically attending and participating in the context of the actual class while it's being run, or by posting in response to the tutorial problems on the Moodle website. I think we need to be flexible about, what works, what doesn't work, and what reaches the greatest audience. And I'm very open to that. And I'm interested in your suggestions for how we can improve things to make things more responsive, more dynamic, but in a way that is appropriate within what we need to do in terms of the learning space. So I consider this to be an evolving context, I suppose. But at the same time, I have to make sure that I'm setting appropriate benchmarks, that there's a degree of certainty and reliability in terms of assessment, and so on and so forth. So, but please, if there are innovations or things happening out there, if I can say this in student land, for example, which you're finding very effective and useful, please bring them to my attention. And if through a dialogue, if we decide that this is something appropriate to incorporate into the process, then yes, I'm very open to discuss that. Also to bring it up in our faculty meetings and Stephen and whatever. We are, we're always talking about various features, various aspects of the program. One of the things is that not only are we working in an evolving space with technology, but, this is a young program as well. It's not like a lot of the other, law schools that, been in existence for, I won't say millennia, but you know what I mean, a while. And they've got their suite of courses, they've got their suite of core and elective courses to some degree established. Every so often, every few years, they may go through a curriculum review process. We're in a space where we're evolving the program. We've got the core requirements of the course, but we're evolving and we're thinking through how things occur and so on and so forth. The property law courses that you folk are studying are not the same courses that the students would have been faced with when, those first cohort that came into the program. Because I have undertaken, a review and a rewriting, substantial rewriting of the property law curriculum to bring it up to what I believe is what my students need in terms of a good grounding and a rigorous grounding in property law. So, and that's happening in other areas as well. But that's my response, Samuel. Yeah.
Thanks very much, Michael. I'll send something through to you, and hopefully my other friends in the course won't mind that I've shared that link.
Well, you can. I mean, in fairness, of course, raise it with them first, and that's the appropriate thing to do. But you can certainly, in an email, scope to me what the idea that you have and the concept that you have. Once you've cleared it with your colleagues, we have to be thoroughly professional here, as we would be as lawyers. Then you can share a link. And actually, that's an interesting point, just before we start getting into the substance of today's class, is that, I'll just share this with you. I'm going to give a presentation in a couple of weeks' time, professional presentation to a group of fairly senior lawyers. And the theme that they've asked me to talk on is new technologies and ethics. And one of the other areas of interest and expertise, or interest in a better way to put it, that I have is ethics, applied and professional ethics with professionals and with other groups and so forth. And the point that you've just teased out, I think, is a very interesting one because, with the way that technology is changing and moving forward as quickly as it is, it's very easy to quickly make a decision to do something without remembering what is the ethical, professional responsibilities that one has as a lawyer. And getting that mix right between the need for dealing with matters, dealing with issues in an efficient and in a timely way, but with time being compacted through the technology space, but continuing to take time to consider the ethical and the professional implications of decisions we're making, where, for example, through social media, something that goes up on social media is there forever, for instance. These are matters that we have. I mean, to me, the carrion call, if you like, is being prudent, being careful, and being thorough. what was interesting in reviewing some of the responses or the posts to the problem questions for today's topic is that I don't think some responses were as thorough as I would have liked, and you know, maybe the responses weren't thought through as carefully as they should have been. But, you know, I mean, there are time constraints and a whole lot of things happening throughout. But, you know, these are the benchmarks against what all of us are. Our performance is gauged at the end of the day by our clients, by our employing senior lawyers, partners of firms if we go into practice. If we're working in an organisation and we're working in a legal capacity, by our managers and so on and so forth. But our clients, those whom we serve, the interest in whom we work, that's the fundamental. That's why for me, in my context as an educator, as a tertiary educator, my primary client group are my students. So I must be fundamentally attuned to the needs of my students and expectations of my students, but I have to set parameters and boundaries around how this occurs. But the thing that I find really interesting and exciting, I suppose, about working in this type of program is that most of my students, of course, are like those of you that are in the class now. You're mature age, you're adults, you've got a whole lot of things going on in your life, you're balancing a whole lot of considerations, but you're here studying law for a reason and for a purpose. And in a sense, I consider us as you know, shared participants down the road, down the journey. You know, I've got a few more notches, I suppose, in terms of law, but you know, I'm a facilitator of your learning. It's a very different model to someone just standing out in front of students sitting in rows and just learning and you know, taking in. Of course, I know, you know, of course it's appropriate that you would be, you know, listening to what I say and so forth and thinking about that and making notes and whatever, and that's you know, that's as it is. But it's very much a shared journey. And you have things to contribute from your life experience, from problems, issues, dilemmas you've faced in your work environments, your professional environments and other contexts that you can feed into your learning about the law that then gets reinforced by the structures and frameworks and so on and so forth that we look at. All right, so with that primer, let us go into today's topic of what's referred to as disposing of interests in property. Now, this idea of disposing, it's interesting that that's the word that's chosen. And of course, I took that title, there's no magic in this, but I took the title from, of course, the chapter in the textbook, or in the casebook. But it's a very good word because it actually captures the different ways in which you can transfer or dispose of an interest that you have in property. Basically, two types of disposing. I mean, there's both. We've got, if you like, in this topic, and you know, throughout the course, we're looking at property both in terms of personal property and in terms of land. You know, increasingly, you can see I'm moving in this direction of land. And I'm not going to call it realty. I'm not going to call it real property. I'm going to call it land because that's what lawyers refer to, okay? And, you know, increasingly, of course, into land law, we call it land law. And I've called that the course because I think that's the appropriate title. So personal property, which can be goods or a range of other things. When we get, for example, to the last topic on the new PPSA framework, and those materials will be available very soon for you, you'll see that the range of personal property captured in that framework is actually quite extensive. But anyway, up until now, we've been mostly, you know, concerned with the idea of goods in terms of personal property and land. So they're the categories of, you know, broad categories or the division of property. But in terms of disposing, we can dispose essentially in two types of ways. What are they?
Could transfer your interest, or you can actually sever your interest. You
can. That's an interesting response, Kelly. Severing, yeah. Okay, well, can I just put severing to one side because that is interesting, and yeah, we'll deal with that separately. But you can transfer essentially in two types of ways. How can you do that?
By gift or by sale?
That's Robin?
Yeah, that's Robin.
Yep. Yeah, exactly. So basically, you can transfer by sale. So, sorry, I'm just making sure I get a copy of the attendance. You can transfer by selling, okay, where you're getting valuable consideration in return. And remember, of course, that, you know, going back to your contract law studies, value is what's value to the promisor. It's not what the law determines to be necessarily of commercial value. So you can sell your interest, basically, okay? That's one. And the other one is you can gift your interest, okay, which means, of course, that you're not getting anything in return. What's the technical phrase that the law uses or property law uses for a gift?
Would that be the love and affection born between the parties?
Love and affection. That is interesting. Oh, very interesting.
I'm coming from a conveyancing perspective.
Oh, thank you for that. No, it's very good. No, I'm not looking for that. Starts with a V. We talk about a voluntary transfer, and we'll get to Corrin and Patton's case, the very important and significant case of Corrin and Patton. I'm sure you had lots of fun reading through the judgments of Corrin and Patton and the earlier High Court decisions referred to in the joint judgment in Corrin and Patton. But a voluntary transfer, that is basically where there is a transfer of an interest in property, in land, but nothing going back to the transferor, okay? And of course, one of the things that we need to investigate is, how do we know if the gift holds up, if you like, from a legal point of view? And that issue relates to the perfection of the gift. Is it a perfect gift? Can it be cancelled by the transferor or the donor? Of course, in the context of a voluntary transfer or a gift, we talk about a donor and a donee. Can it be cancelled or wiped out or rescinded, brought back, and so on and so forth? All right, so that's the breakup of what we're looking at, really. Don't forget, again, I mentioned this just in the introduction to topic 8, that this is an area of property law that is governed both by the general law, and of course when we refer to the general law we mean the common law rules and the principles of equity. And as we've seen in the topics to date, equity plays a big role in property. There's a lot of equity in this course. There's also references to trusts in this course as the perfected form of an equitable interest. I know that we have separate courses on equities and trusts, but we do a fair bit of that in this course as well. But in addition to that, we cannot forget or lose sight of the significance of the Property Law Act as the key piece of legislation in Queensland, and it crops up in various places from time to time. So again, you're in terms of the legal framework in this area, you're needing to grapple with both general law principles found in common law and also in equity and how they interrelate to each other, and also statutory provisions. When we move into land law in term 2, we'll see a greater emphasis on statutory provisions, particularly when we start to investigate Torrens title land and the various types of interests that then can arise in land within the context of Torrens title. But that's for next term. One of the other things partly this material and this topic looks at is go back to the idea of the form requirements, formality requirements, the need for things to be in writing or not in writing, or is it adequate for there to be things to be evidenced purely orally? And again, the Property Law Act gets onto its back legs and says, look at me, in terms of form requirements. And we see, for example, there on pages 11 and 12 of the notes I've referred you, for example, to pages, sections 10, and also then there's a reference to, I think this is section 11 as well, but also notice a reference to the Land Title Act as well. Bottom of page 12, a reference to the Land Title Act. And so there's not only the Property Law Act, but also other pieces of legislation relevant to this topic. And again, I remind you, of course, which is on the welcome page of the website, but there is that reform initiative on foot in Queensland, looking at all of the key pieces of property law legislation. So I just remind you to go to that, the Queensland Attorney General's Department from time to time, just to see what's going on there. They will issue discussion papers, but we're certainly not at a point yet where we have any changes to the legislation. And then where we finish off with is by looking at this idea of detrimental reliance on a representation and essentially focusing on the concept of the concept of estoppel. I was about to say the equitable concept, but of course, if you've gone through the topic and the cases, particularly Walton Stores, the lead decision, which I've asked you to consider, you'll be aware, of course, that we have both common law estoppel and equitable estoppel. And now we generally tend to talk about, promissory estoppel in Australia rather than the differentiations that exist. And in the UK, for example, those differentiations continue to abide to a degree which is probably not relevant here in Australia post Walton Stores. That's a concept, of course, that you will have looked at in your contract law studies, but it crops up here again in property law. All right, so without further ado, let us launch then into the problem questions for today. And the first of those is problem 16 on page 38 of the notes and in the forum. I might just say before those that are with us comment, I've read through all of the posts on the Moodle site for these questions and some very nice responses there. I might just say that in my determination at this point, there were we had 15 responses posted to problem question 16, and of those we had about 7 which I thought were at pass level, about 4 at credit level, and about 4 at distinction level. You will note the absence of any high distinction answers, but that's how it is sometimes. All right, so let's open up discussion for problem question 16, please. All microphones are muted. Someone going to... Samuel, thank you.
This question really made me think, which I don't like to do.
I can't believe that, sir. I can't believe that. I can't believe you don't like to think. Sorry, that's my response. Okay, go. Yep.
I grappled with the idea between the perfection of the voluntary transfer versus why the transfer couldn't happen based on the initial intent. And I had to look at the incompleteness of it was really, I guess, I don't know, for the ratio behind it was the incompleteness of it. That Corin didn't affect an instrument of transfer.
Samuel, can I just ask you, it would help, I think, just give us a bit of overview in terms of what's going on in Corin and Patton, in terms of the factual matrix. Just a broad, in your own words.
Okay, Corin and Patton, Mr. and Mrs. Patton wanted to sever their joint tenancy in land, which was registered in New South Wales under the Torrens system.
Can I just stop you there? And of course, we don't, and this is to the benefit of those listening to the recording as well, we don't fully appreciate, although, you in the course, you don't fully appreciate what the concept of joint tenancy is, okay? Now, in terms of ownership, it has nothing to do with landlord and tenant, by the way. Some of you may know what it is, and some of you may well be in practice environments, working as paralegals or whatever, and therefore you may have be conscious of this. But it's a form of co-ownership, and we'll learn more about that in land law. It's a form of co-ownership. So basically, the Pattons were co-owners of this property, right? Okay, Samuel, yes, please continue.
Yeah, please go on. I'm learning more from you. Okay, so in a rough way, they were co-owners, and they engaged, I believe, Smallwood, who was a solicitor, to sever this joint co-ownership.
Yeah.
I still don't know who it was supposed to go to. All I know is that it was supposed to be severed. And Mrs. Patton was terminally ill, and Smallwood and Corin, who is Patton's brother, I'm taking this as Mrs. Patton's brother, created a deed of transfer and a declaration of trust. It was signed by Patton and Corin, and taken away by Smallwood, who's acting on their behalf.
Can I just stop you there? That you're going well. Can I say that? Going very well. But just interjecting a little bit by adding a few dimensions. And again, this is an example, yet another example, and we've seen some examples earlier, for example, where we were looking at, and there's a couple in this topic actually as well, a couple of cases, looking at mortgage interests, and you haven't studied mortgages, so you don't know the full law on mortgages, property law on mortgages, and so it's a bit challenging. Again, with regard to the joint tenancy, this is about a form of co-ownership. But what's particular about a joint tenancy? I mean, there's two forms of co-ownership. So you can have a joint tenancy, or you can have several owners owning as what are referred to as tenants in common. Now, the critical difference between these is that tenants in common have their shares of ownership specified. If it's Torrens title land, they'll be specified on the certificate of title. So that Mrs. Corin owns 30%, Mr. Corin owns 70%, or vice versa, or 50-50, but it's specified. They can then transact in their share. They can will their share subsequently, okay? With a joint tenancy, there is a principle of law that says that when one of the joint tenants dies, the surviving joint tenants take the whole. So in this scenario, Mrs. Corin was terminally ill with some terrible illness that the facts in the case reported don't tell us. When if she hadn't acted in what she thought was to effectively sever the joint tenancy, who would have taken the property on her death?
Mr. Patton.
Yeah. Now, obviously, there was some reason why she didn't want him to take the whole of the property. Now, this also, interestingly, and this doesn't fully emerge in the facts, takes us into the fact that in property law, especially land transactions, not so much, I would say, with regard to personal property, but particularly with land transactions, and you'll see this, through this case, and you'll see this even more next week when we look at topic 9, that there are fractious issues going on between people that are otherwise linked and related to each other in various ways, whether in marriage or through de facto relationships or whatever, but then something happens, breakdown of personal relationship or whatever, or even in a business context, breakdown of business parties, being happy to work and whatever and share things together. and then they don't want to allow that arrangement to continue in terms of the property interest that had been reflected through their property interests. And we find many cases emerging and ending up, as giving us principles of law where the fights over property have emerged from a breakdown of relationship, either personal relationships or familiar relationships or in business. These are, as we know, common ground in terms of humanity, but these then work themselves out in terms of what had otherwise been secured interests in property in a different way. Okay, so that's the sort of little bit of the background there. So we've got an attempt by Mrs. Patton to sever the joint tenancy. She then put in train a process involving her lawyer, who put documents in place, had them executed, believing that had been done. Okay, and then what happened then? Just in terms of the facts, just close the loop in terms of the facts for us, Cindy.
So after the documents were executed, they were taken away by legal counsel Smallwood.
Yeah.
Certificate of title was held by the Bank of New South Wales, and Mrs. Patton never took steps to transfer that title, so it's registered just, I guess, in her name. And then she died in 1984 and appointed Corrin and Jones as executors. And I believe that the matter was then between her executors and Mr. Patton subsequently.
Because if the joint tenancy had been effective, who would have got her interest in the property?
Corrin.
If the joint tenancy had been effectively severed, who would have got her interest?
Her brother.
Yes. In this case, whoever she nominated as the beneficiary of that interest under her will. Yeah? Assuming she had a will, and in this circumstance, I'm sure she has a will. Absolutely, she's not going to proceed through this process without having a will in terms of how she wants her property to be dealt with on her death. But if the joint tenancy is not effective, who gets the interest?
Mr. Patton.
Yeah.
The survival. Yeah.
Say again, sorry, Kelly?
It's Jessica. I just said her husband as the survivor.
Yeah, exactly. So, there's obviously, hi Lisa, there's obviously something going on here in the background between why she doesn't want her husband to get the full share of the property, or become the 100% owner of the property. She wants her share to pass in a different way, even though that's how they'd originally purchased the property. And let me just say that in familial situations, particularly in personal relationships, in couples who are married, even increasingly in de facto, but de factos tend to think more about this than couples that have pursued a marriage option. How they purchase property is very much defaults to joint tenancy, because the contract of sale actually has joint tenancy printed on the contract as the default option. You have to actually manually change that to be choose tenants in common and specify the shares. And at the time when that's done, very often people that are in a committed relationship, not believing there's going to be any problems, just choose the joint tenancy option. But then subsequently problems can arise, as we all know. Not all personal relationships go unendingly without issues, without hiccups. And then if there are property interests involved, then there's a flow-on effect. Okay. So there's the scenario. Let's go back to problem question 16, because it's getting you to focus on the role of the earlier decision of Brunker, and in particular the decision of Dixon in Brunker, with respect to Torrens system land, in a circumstance where really what we have here is we have, a purported gift of this property, and we then, that's to the brother, assuming that the severance is effective. let's go back and respond to that question. Does someone want to engage a bit with the actual question in problem 16? Jessica, is that?
Yeah, I struggle a bit with understanding this judgment as well, because the gift still wasn't acknowledged as a proper transfer. Was it not?
Indeed. What was the problem?
Well, as the housekeeper, he didn't transfer the deceased didn't transfer the gift to her somehow. I'm not sure what exactly the legal issue came down to.
The housekeeper, how are you referring to a housekeeper?
Isn't there the appeal and the housekeeper? Or have I got that totally wrong?
I think you've got this a bit confused there. We're looking at here in Corrin and Patton, we're looking at property that's jointly owned.
Oh no, I was looking at Branca.
Yep.
Sorry.
Yep. So let's focus on the scenario in Corrin and Patton. But why is the question tossing you back to what Dixon said in Branca's case?
Oh, look, I'll have a go.
Yep.
That I don't have the question in front of me, but I have my answer. The equitable interest doesn't pass until registration, was what was held in Branca. But then I've got down that Branca's not good law anymore, and that they've reverted back to Milroy. And I think the problem with Mrs. Patton was that she'd held on to the certificate of title. So I don't know why she would have done that. Maybe she didn't really want to make that gift, or whether it was...
She didn't hold on to the certificate of title. Who had the certificate of title?
No, it was the solicitors.
No, not the solicitors, someone else.
The bank.
The bank. Because what often happens is where there is a mortgage over the property, right, initially, then the certificate of title gets lodged with the bank, historically, but to effect a transfer, you not only have to have the form of transfer, you need also to have the accompanying certificate of title, which will then be lodged with the Land Titles Office. Now, the Land Titles Office has a duplicate of the certificate of title, so the one issue that arises is, do you really need the CT? But if the CT still has to be sought, for example, by the donee, but that's something that the donor really was at their power to get access to and to put it, with the transfer, then one of the points that comes up is, well, has the donor done everything that really they should have done or was within their capability to do so that this gift could be finished, if you like? And equity would say, yes, it's perfect, there's nothing more to be done. Okay, this was part of the issue that was coming up in Corrin's case. But going back to Branca, look, if we go back and have a look at what Dixon said in Branca's case, right, so you can see, for example, on page 27 of my notes, in the within the judgment of Corrin and Patton, in Branca, Dixon said, in the context of a case involving a voluntary transfer and an estate and remainder expectant on the death of a donor, so that just means that what was going to actually be transferred at the death of the donor. The question is not, this is Dixon speaking in Branca, the question is not whether the intending donor has divested himself of his estate or interest in the land, or has done all that lies in his legal power to do so. So Dixon's saying that's not the question. The question is whether by his acts, could be her acts, he has placed the intended donee in such a position that under the statute, the latter has the right to have the transfer registered. Right? The question is whether by his acts he has placed the intended donee in such a position that under the statute, that's the Torrens statute, the latter has the right, that is the donee, has the right to have the transfer registered. Right. Now, if we come a bit further down...
Can I ask a question on that?
Jessica, yep.
Jessica, sorry. If you've done everything you could possibly do, haven't you actually executed the transfer? How can you have done everything but not have actually fully completed the process? Because if to effect the transfer, you also, the form of transfer alone is not enough. We need the copy of the certificate of title to accompany the transfer to be lodged with the Land Titles Office. And the certificate of title was held by the bank. And of course, as the registered proprietor, Patton could recall that from the bank. That was something that Patton could do. But Patton didn't do that. Yeah? So this is... Okay, so there's actually an administrative process that has to be considered, not just a legal one.
Say again?
There's actually an administrative process that also needs to be fulfilled, not just a legal one.
Well, the point here is that what the court is really trying to say is, in the end, and I'm going to get back to Griffith and Anning because that's the view that they preferred ultimately, if the donor has done everything that they need to do to put the donee into a position, in the case of Torrens land, where they can register, then that's fine. But if they haven't done all that they need to do to put the donee into a position where they can do that, then Equity says, well, we're not going to help you, basically, because you haven't done all that you should have done. And this is gets to this idea of perfecting gifts in equity. What is equity prepared to do? And partly this requires you to think about the role of equity, okay? And remember that this also requires you to think about the history of where equity emerged out of. And basically, we had the common law framework first, and then equity emerged. It followed common law to a point, but then it was concerned about justice and fairness and conscience, and where those matters were of more importance, it would deviate from what common law required or expected. And we see that in various cases, and we'll see it when we get to problem question 17 as well today. Right? If we go back to Corrin and Patton and just to the joint judgment again, so we've got that reference earlier in the joint judgment to Dixon and Brunker and the approach that he follows. The joint judgment preferred, they said, preferring the approach of Griffith and Anning, and this is on page 28 of your notes, despite the support for Dixon and Brunker. This is what the joint judgment then said. Griffith's approach, referring to Griffith and Anning, Griffith's approach has the advantage that it gives effect to the clear intention and actions of the donor rather than insisting upon strict compliance with legal forms. It is a reflection of the maxim, equity looks to the intent rather than the form. That's very important. Equity looks to the intent rather than formality issues. Common law often looks to there are form requirements, and if form requirements haven't been fulfilled, then you don't have any redress. You know, for example, in contract, that if there's no consideration, no contract, because there has to be value for an enforceable contract, and that's what common law specifies, for example. And then the joint judgment goes on. It is a reflection. Oh, sorry, I mentioned that, a reflection of the maxim that equity looks to the intent rather than the form. By avoiding unnecessarily rigid adherence to the general rule and endeavouring to give effect to the donor's intention, the law avoids unjust and arbitrary results. You see, by the time we got to Corrin and Patton in 1990, the High Court was able to say that this is really the role of equity. This is the clear role of equity, okay? That is, it will intervene to avoid unjust and arbitrary results. It adopts a flexible approach and it focuses on substance rather than form. But of course, it's not just an open-ended open slather, if you like. It still has to work within the evolution of principle and so on. So if we go back to what Griffith said in Anning and Anning, which is documented in the early part of the my notes on Corin Patton's case. So back onto page 26 to 27 of the notes. In Anning and Anning, Griffith said, I think that the words necessary to be done, going back to the earlier English decision of Milroy and Lord, as used in Milroy and Lord, mean necessary to be done by the donor. If, however, anything remains to be done by the donor, in the absence of which the donor cannot establish his title to the property as against a third person, the gift is imperfect. The court will not aid the donee, sorry, there's a typo there, as against the donor. But if all that remains to be done can be done by the donee himself, so that he does not need the assistance of the court, the gift is, I think, complete. If we go back to Milroy and Lord, the earlier case of Milroy and Lord, which was a 19th century English case, there the English Superior Court said in the case of gifts, the donor must have done everything necessary to be done in relation to the particular property so that the transfer and the gift are binding. And if the gift was intended to be given effect to by one method, the court will not use another method to effect it. So this emphasis on having to be done all that could have been done. In other words, in this case, basically, if you boil down those complex interconnections, but you can't do this until you've gone through that process. That's the reason I structure things in this way. What the court is saying is that equity will intervene where justice and conscience demand, but that's not unbounded. But it will examine the behaviour of the key players, in this case the donor and the donee, rather. That is the one giving the gift and the one receiving the gift. And remember that there are differences here between circumstances involving a gift in relation to an interest in land as opposed to a sale where valuable consideration has been given. Okay, and in examining the behaviour and the conduct of those involved, and in particular the donor, the court is really looking to see whether the donor has acted in a way that is just and legitimate in all the circumstances, in doing all that they could possibly have done to have equipped the recipient of the gift, the donee, to then get what they were being given, that is the interest in the property. If they hadn't, really the point is that they had, arguably been lazy, or you could use the word careless maybe, but we have to be careful with how we describe their behaviour, because the law and the court has taken a particular view about how to describe behaviour. But clearly in this case, because of the significance of what's at stake, we're talking here about a 50% interest in the property that was in the hands of both Pattons as joint tenants, okay? And this was only part of the decision, because the other part that we'll look at a bit later when we look at the idea of co-ownership and severing a joint tenancy, the court also had to ask, well, had there been an effective severance of the joint tenancy? In the end, of course, as you know from looking at the case, it will, you're clear that in fact that wasn't what had happened. So that, for example, on page 29, in the end, in this case, the judgment decided that the transactions failed to pass equitable property from Patton to Corin. The gift was incomplete, and Patton could have recalled the transfer at any time. Recalled the transfer because it didn't have the certificate of title with it, because the certificate of title was still sitting with the bank or with the financial institution.
Can I just ask, why would the title be with the bank? Would that be because there's still a mortgage on the property? Because if you extinguish your mortgage, you always get your title back. So does that mean it had a mortgage on it?
Not necessarily. Remember, in 1990, we were not dealing with full computerisation of the register. So we were still dealing with paper documents. And the original CT was a very valuable item with respect to proof of ownership of property. Yes, you could go and do a title search of the land of the Torrens register, and it would reveal who were the registered proprietors. But this document was a critical document. So very often it's a document, amongst others, but it in particular, if you have that sort of interest, would be held with a bank for safekeeping. One of the practical reasons is because, for example, if you had a fire in your property and the certificate of title was destroyed, short of doing a search, if you needed to prove that you were the owners of the property, this may become or may prove to be challenging. So, very often, historically, documents like those, important property law documents, wills, for example, is another one, were often held either with a bank or in a safe deposit box or with your solicitors. And historically, again, and I can, when I was in practice in Sydney, we just a few years ago, we had a special room in the solicitors' offices that was fireproof, and all of property title documents and wills were kept in this fireproof room, and it was closed at all times except when you had to access the documents, and then you'd get access to it, but it had to remain closed in case there was a fire in the premises of the firm. So there are practical reasons here, and also security reasons. Yeah. I mean, it may well be the case that the document was there originally because there could have been mortgage over the property, absolutely. And there could still have been mortgage over the property, but there's another reason why they could well have been with the bank as well. Yeah.
Okay, thank you.
All right, so we dealt with 16, I think we have. How we go about perfecting the gift in equity. It wasn't complete in this case. Yeah. So the point is, that, just to wrap that up, no, the view of Dixon that the donee of Torrens title land only acquires a statutory right to register, no, that's not the view that has held sway ultimately since following the decision in Corrin and Patton. Corrin and Patton has reinforced the earlier view expressed by Griffiths in Anning and Anning following Milroy and Lord, and re-emphasising the focus on this idea of that equity proceeds by focusing on what is just and what is according to good conscience. But in doing that and applying the framework, it is mindful to examine the conduct of the relevant parties or persons, and it doesn't just leap in and rectify everything when those involved could have done more and should have done more. That's the point. It's often a very fine line here in terms of how equity works. And, this is where we have to be careful, because equity has evolved as a separate framework of principles of law that get carefully applied, but the language of equity is more open and is more flexible often and more responsive than common law language within the common law cases. So it's just something that you have to garner as you go by seeing these, what I call the nuances of differentiation, basically. It's part of the magic and the joy of learning the law in a common law jurisdiction. I mean, today, of course, the practical reality is that the common law rules and the principles of equity are accessed through the one court at superior court level. So you can't get access to an equitable remedy at a lower court. You need to go at least ordinarily to the Supreme Court. But it's the one judge who can actually, subject to what's being sought by the parties, seek to apply common law and equity. Historically, these were different. They were different courts, so you had to go from one courtroom to another court, that was the case. I mean, even today, for example, in New South Wales, we have an equity division and within the Supreme Court. But that doesn't mean that in other contexts a Supreme Court justice can't apply equitable reasoning in the resolution of dispute where that's appropriate based on the arguments presented by the parties. Okay. All right. Let's move on to problem question 17, which takes us into the idea of detrimental reliance and the concept of estoppel. And this is broken into 3 parts, so you know someone can have a go at the first one, and, you know.
Can I just ask a question before we get into this question? I need to get estoppel straight in my mind. Common law estoppel, are you looking for contracts? So, pre-question. So if there's no contract, it means it's not a common law estoppel, it's an equitable estoppel. And there used to be proprietary and promissory, but proprietary was to do with land and promissory estoppel was with anything other than land, but now they're fused because of the Walton Stores decision. Is that all right, basically? Because I found it very confusing reading all of this.
I've got a response. I'm just wondering if anyone else has got a response before I make my response. It's not, by the way, Lisa, that's nice. The way you've explained the challenge of estoppel, that's a nice way of explaining the challenge of estoppel. Because when one confronts it for the first time, well, I have to say not only for the first time, but certainly for the first time, it is. You know, it's very much the case where you can be uncertain about why have we got all these forms of estoppel and what have we got today and how we got there, and yeah, that's entirely understandable. And, yeah. Has anyone else got to make a general comment about response to what Lisa said before I say something? Silence is golden. That's right, that's fine. Look, you know, again, what I would say to all of you, and you know, those listening to the recording ultimately as well, is it's a very good, this idea of estoppel, I think is a very good area to try and not lose sight of, if I can say, the trees for the forest. What do I mean by that? On the one hand, you need to see that because we have these 2 frameworks of general law, we have rules and we have principles emerging from these 2 frameworks of law, okay? So we have common law ideas, we have common law concepts, and we have equitable concepts. And we have equitable ideas, and they are, you know, merrily dancing along in, you know, if you like, down their own pathways. Okay. Now, if we remember that common law tends to be about things that are more certain, tends to be about things that are, and tends to be, you know, really more heavily governed by the doctrine of precedent. We cannot deviate, if you like, from the incremental evolution of the rules framework as it evolves over time. We get a better grasp of how it is we've got, for example, in this area, different types of estoppel emerging. The idea of estoppel, what does estoppel mean? The word estoppel.
To stop.
We'll take Robin first.
Sorry, I just said to stop or to prevent someone from doing something.
I think the word prevent is better, okay? So to estop, that's what it is, estoppel, okay? It means to prevent. Of course, estoppel can be both, operate in a positive and a negative way. It doesn't always have to be negative, but it's restraint, if you like. I'm not going to say a restraining order, but it's a restraint on what can be done. And then we need to examine what's the basis of claiming that restraint, okay? And you can imagine that common law is concerned with things that have happened. It's not concerned with maybes and possibilities, because that's very uncertain. How can we work out what that means, okay? And not only are we then also concerned about things that exist and things that have happened, if you like, but we're more concerned about the ideas of behaviour that the common law is focused on, that there is reasonable way of conducting yourself. People aren't being careless or negligent or fraudulent, possibly. That can emerge and seep into equity as well. But there are bases in common law for challenging action and decision. Yeah? So there was a response by common law to stop behaviour and conduct or decision in some circumstances. On the other hand, equity was more flexible and historically and was concerned again sometimes to redress the strictures and the restrictions that common law had, and partly it was trying to again focus on this concern for justice and concern for making sure that parties acted according to good conscience. So this idea of unconscionability starts to emerge and creep into existence. And also this idea of keeping people to their promises, and if they're behaving in a way that is allowing them to walk away from their promises in any situation where there's been a response to a promise and people are out of pocket, or there's the law identifies the elements of detriment and reliance and relied on the promise. This comes up in Walton Stores, and there's financial or other detriment has been incurred. Then equity will step up and say, well, that's not right, that's not acceptable, and let's examine the behaviour of the person or the entity making the representation, right, or the conducting themselves in a certain way, to see whether there is justification in allowing the estoppel to work to prevent the party walking away from their promise, if you like, at the end of the day. So, and then we also had a difference between how estoppel worked where there was an interest in land and how it worked where things were just, underpinned by a contract. So we had promissory estoppel linking back to contract, where contracting parties were held to their promises, because as you know from your contract law studies, the promissory character of a contract is absolutely fundamental to the definition and understanding of a contract at law. In circumstances involving interest in land, we developed a slightly different principle, which we call proprietary estoppel, because of the significance of the interest in land. And how would this idea of estoppel work when there was an interest in land that was at stake? Now, in Walton Stores, and we'll come back a bit in a minute to the factual matrix of Walton Stores, because it is interesting. But, it's clear that the court is, the joint judgment is finding this differentiation of estoppel a bit unhelpful, to put it like that. Clearly, some of the judges, as some of the posts to this question on the Moodle site reflect, are happy to stay with the current classifications and they're not going to take the step. This is always the thing that you're looking for. Is the judge prepared to take the step? We're talking at the level of Court of Appeal or High Court. Are they prepared to take the step to say the law needs to be, further evolved? Or am I happy with the classifications and the way in which the principles and the rules matrices exist at the moment? And of course, the interesting part from our point of view is where there's those judgments that are prepared to take that step to evolve the law further. The High Court under Mason, I think, was very often prepared to do that, to clarify, to sort things out, and to augment some fracture or fragmentation, which had just a part of the evolution of the law, if you like. So, for example, if we go to what they said was the principle of equitable estoppel, which is what they focused on ultimately in Walton Stores, this idea of equitable estoppel rather than other forms of estoppel. They say there, this is looking at where I capture that part of the judgment on pages 33 to 34 of my notes. The foregoing review of the doctrine of promissory estoppel indicates that the doctrine extends to the enforcement of voluntary promises on the footing that a departure from the basic assumptions underlying the transaction between the parties must be unconscionable. So there's that critical idea of unconscionability. A failure to fulfil a promise does not of itself amount to unconscionable conduct. Mere reliance on an executory promise to do something, resulting in the promisee changing his position or suffering detriment, does not bring promissory estoppel into play. Something more is required. What is that? Humphrey's estate, that's an earlier case, suggests that this may be found, if at all, in the creation or encouragement by the party estopped. So the encouragement is by the representor, if you like, in the case of where a representation is being made, either by conduct or behaviour or by information. Encouraged by the party estopped in the other party of an assumption that the contract will come into existence, or, so not just contract, so a contract is an example, or a promise will be performed and the other party, even when we don't have a contract, okay, the other party relied on that assumption to his detriment to the knowledge of the first party. So reliance and detriment, right? These are the fundamental elements within the doctrine of promissory estoppel as it has emerged since Walton Stores and is relevant for Australia today. So, good question, Lisa, because there's been, there was an amount of fragmentation before Walton Stores. I have to say to you that the position that's now in Australia, and of course Walton Stores doesn't do away with the other areas of estoppel, but basically what it does is it consolidates our understanding of promissory and equitable estoppel, and now focuses on this refers to it in a general way of promissory estoppel, and it also breaks down the need to distinguish between proprietary estoppel and promissory estoppel in the Australian context. But that is not necessarily the case in other places. So that in the UK, for example, it is still, there is a clear body of discussion looking at proprietary estoppel as well as other forms of estoppel. So the way that the court has approached the evolution of the concept of estoppel in the Australian situation, don't assume that that is necessarily reflected in other common law countries, even including England, for instance.
So based on that explanation, is it safe to say that we can lump them together, or should we still be cautious of doing that?
What do you want to lump together, Jessica? You want two lumps or three?
Equitable and equitable and proprietary estoppel.
What do other people have to say?
I was going to say promissory and proprietary have become equitable, So are we really just dealing with common law estoppel and equitable estoppel now in Australia?
Any further contributions? Yes, that's basically the position post Walton Stores, and so I've used this word fragmentation in the various aspects. We don't need to have that degree of fragmentation, and one of the reasons for that is that because how we've evolved, in terms of the law, and I have to say that great thanks to the Mason Court for this, and that's actually highlighted in that I've given you a YouTube clip on the launch of the Property Law Review in Australia, if you've had a look at that. And there's presentations there by Professor Edgeworth and by Sir Anthony. And the Mason Court, I think, did a lot to help to solidify and to firm up the basic principles that we have here, and in particular that we have common law and we have equity. But then, in thinking about equity, let's focus on the main concepts that drive equity and when it will be available, rather than getting into this breakup between whether it involves an interest in land or it doesn't involve, or it involves a contract. Historically, you see, this is a theme that I've lead you through a bit in the course. Historically, there were these clear demarcations between different areas of law. So we had private law and public law. Within private law, we had clear distinctions between property, contract, tort, for example. But hopefully by now you've seen that to some degree these distinctions are a bit artificial. They're artificial because there are overlaps. We've seen in this course that there are overlaps between private law and public law. We've seen that constitutional law and an understanding of constitutional ideas and the idea of sovereignty feeds into what it means to understand what property is and the property interest that can be asserted. We've also seen that there's an overlap between contract and property. And in this area, with regard to estoppel, we're seeing that. We've seen that a bit earlier also, earlier in the course when we were looking at different situations that asks, is the interest that's being asserted here more contractual or more proprietary, and is that a differentiation or classification that's still important? That doesn't mean that we don't have bodies of law, contract and property, but that there's not rigid differentiations between these, and at the margins there can often be a degree of overlap, particularly in the approach and in the way that we think about the issues at stake. We'll see that more, for example, in land law, when we look at leases, not Lisa, but leases. And the other thing about that is we actually focus on general law leases. We do not look at residential leases very much in that topic in land law. We focus on general law leases and the legal framework that underpins a general law lease. What I mean by that is not a residential lease underpinned by RTA legislation. But that we'll see in that context that contractualist thinking and contractualist jurisprudence very much informs how we understand this property law entitlement, which is a lease, an interest in land as it is now. So, that's where the court has led us to, and it is also in equity helped to emphasise those more fundamental ideas that we are concerned with, and that is a concern for seeking to attain a just outcome, seeking to focus on the conscience of the actors, seeking to examine that, and then, but also there is an elemental structure. So it's not just a very open, flat idea of fairness. It's more detailed and more complicated than that. But that's what we're focusing on. So yes, that's what we come to at the end of the day in terms of this idea of estoppel. Have we answered? Maybe we've answered all those questions, or three, as we have progressed. Look, is there anything that anyone would like, anything more about the idea of estoppel, or about anything else in the topic? I didn't give you a question, for example, on the difference between form and substance. A very important idea as well, and I think that again, the common law tends to emphasise form requirements, whereas equity, as it's understood today, very much is a focus on the substance of what's happening rather than have certain form requirements been met. It will not, for example, allow justice not to be done or allow unconscionable behaviour to go unchecked merely because a formality requirement has not been satisfied. That clearly comes through from Coram and Patton, but it's also, I think, in substance reflected in the way in which the court has proceeded in the other cases in this topic, and also in the Walton Stores case as well. But it is important for you to recognise and appreciate that those form requirements, are important as well. And as I mentioned earlier, they are captured through the legal framework in terms of the Property Law Act, and the provisions are documented for you there, particularly in relation to transactions involving interests in land. There's often a specification for writing, a need for writing, but we can also see that things we can have oral communications that can somehow play a part, but there is often an emphasis on a need for writing. Can I just take you back to one area, and that is the effect of contracts for the sale of land, which I didn't give you a question on, but and the points raised by Lysart and Edwards, which is an early English case, 1876. But what are your thoughts about what was ultimately held as a point of principle in Lysart's case with regard to, this period between entering into a contract and completion of a contract of sale of interest in land? Has anyone got any comments on that? Maybe I'll read you a critical part of the what was decided in Lysart's case. This is on page 20 to 21 of my notes. The judge, Jessel, said that where we have a valid contract, it converts the estate in equity. It makes the purchase money a part of the personal estate of the vendor, and it makes the land a part of the real estate of the vendee. A valid contract actually changes ownership of the estate in equity. This is when we have a contract, a valid contract that's been entered into, but prior to completion. He's talking about the interests of the parties prior to completion of the contract of sale. Right, but after we've got a contract coming into existence. Any comment or thought on that? Put yourself in the position of being a vendor or a purchaser.
So that would be in distinction to the common law, where you actually become the proprietary owner at settlement or completion date.
Yeah. Yeah. So we're looking here at what equity's response is. Yeah. And I mean, one of the things that I put to you, I mean, there's controversy about Lysart's case, even though we've got, it's almost got to a stage where we talk about the rule in Lysart, as I indicate. But is that do you think that's what the parties would believe they have? Would the vendor, for example, believe that from the time the contract is entered into, that the purchaser actually has an estate in the land, and it's already, the ownership of the estate is in the hands of the purchaser?
I don't think a lay person is going to think that way. I don't think the vendor is going to consider himself a trustee.
Now that's a good point, Jessica, because that's what Lysart is getting at, and that is that the vendor is a trustee for the purchaser. What vendor would ever consider themselves being a trustee for the purchaser from the moment a contract was entered into?
I agree with you.
Oh, multiple responses. Very good. We'll take them in turn. Maybe Kelly, did you want to say something first?
Just saying, it sort of creates a vendor's lieu, and he's holding the property on trust for the purchaser in exchange for anticipating the payment of money.
Is that how the vendor would see his position or her position at that point?
I don't think so, not unless you've got a law degree.
The value of law degrees, man. The value of law degrees, especially a CQU law degree. Absolutely. Lisa, did you have a thought?
Oh, yes, I was just going to agree with what Jessica said earlier, in that I think most lay people wouldn't consider that they have an equitable interest in a home they'd paid a deposit for. But of course, they don't get the proprietary interest until settlement day. But I don't think it would occur to most people. That's the case.
What about this idea that Jessica threw in, and that is this, this idea of a trust? I mean, a trust is the highest form of equitable interest, and it actually carries some pretty significant implications for the person deemed to be trustee.
I agree with Jessica, but I also think that having been a person that's purchased property, I consider that from the moment a deposit is placed, that I have some sort of equitable interest in the property, as well as, aside from my contractual interest in it, from the contract of sale, that I have an equitable interest in that property from day one.
Of course.
I lost everyone.
Of course, the payment of the deposit, and for those of you that have an interest in this, a deeper and more abiding interest in this, can do conveyancing with me as well, in terms to, if that doesn't cause property law overload. But the payment of a deposit may or may not occur at the time when the contract is signed. There may be, depending on what is meant in that regard. We can talk about the deposit in terms of the contract. We can also talk about a small holding amount and so on and so forth. And I don't want to go too far into conveyancing ideas, but of course, in almost all states in Australia today and territories, we have what's called a cooling off period, where parties can are permitted to get out of their obligations prior to full contractual obligations coming into operation at the end of that cooling off period. So we just put that. Robin, did you have a thought? Or?
Yeah, just a question. If once someone gets that equitable interest, if the property is sort of set up as a trust for that equitable interest person, isn't the vendor then the trustee, and don't they owe fiduciary duties to that beneficiary? And isn't that a conflict of interest?
This is right. not so much necessarily the conflict of interest point, but that may be relevant as well. But this whole idea of seeing the relationship between vendor and purchaser in terms of a trust relationship, this is something that, for example, this is the point that I've teased out from the materials at the bottom of page 21 of my notes. The High Court has cast, I'm reading from the notes now, the High Court has cast doubt on whether the relationship between vendor and purchaser in that period, that is between contract and completion, is in the nature of a trust. So the High Court is saying, look, are we really saying that there is a trust on foot, even in the nature of a constructive trust, because there's no express trust, obviously, between the parties, but the trust known to the law, constructive trust, between a vendor and a purchaser in the intervening period. There may well be obligations, certainly, and then the issue arises as to whether or not those obligations are better served via contract or via other areas of enforcing one's rights. Now, Samuel's point was interesting. Still there, Samuel? I'm not sure. Where he said that he was of the view as a purchaser that he had both contractual and equitable rights from a certain early point in the process. That's interesting. I don't know how many purchasers would view that and what amount of rights they feel they have. Most ordinary folk, of course, would look to the contract if they were mindful of any of their rights at all as the basis of, their entitlements. But it's clear that the High Court is not convinced about this trust idea in that intervening period between contract of sale and completion. Anyway, that's some thoughts on that. Again, some controversial material there with regard to one of those earlier cases in relation to contracts for the sale of land, of course, which is the method whereby interests in land get transferred most typically. All right, we've got 3 minutes remaining. What I would ask you to do is to, like we've done in previous classes, is to write down 3 takeaway points that you believe captures the 3 main points that you've taken from today's class. So I just get you to do that now and then maybe share 1 or 2 of those before we finish.
I think one of the points I got was a greater or a deeper understanding of the common law and equity and how they're different, I suppose. I mean, it's a very simple thing to say that they develop from different courts for different purposes, but I think I'm getting understanding the effects of that a bit more in terms of law.
Thanks, Jessica.
I was going to say pretty much that as well, that it's the common law and the equitable estoppel issue is far more clarified for me. And the only other thing to say that I agree with my court, I don't like the idea of a trust relationship between the date of signing the contract of sale and completion of it.
That's fine. That's good. Thanks, Lisa. Kelly, any thoughts?
Yeah, just I'm going to take away the evolution of estoppel. I'm actually going to have a bit more of a read into it because it's interesting to see how it's evolved over the case law. I've got a better understanding of the steps involved in voluntary gift transactions, what the court sees in those transactions. And the question of trust is interesting to sort of think about what actually creates a trust, what's required, and the what the parties are then, you know, liable to do for each other.
Yeah. Thanks for that. Don't forget that, you know, equity, apart from how it proceeds and how it recognises entitlements and the principles that it's using, of course, the range of interest that it can recognise extends from what, on the one hand, the trust, which is the most fully formed equitable interest. And as we know, a trust, of course, we can have an express trust, we can have a resulting trust, we can have a constructive trust. So arising as a result of the express wishes of a settler, for example, or as a result of examining certain assumptions, or as a result of what has been constructed by the law and imposed on the parties for reasons of equity. But we can cascade all the way back down to this very awkward, not fully formed and fully understood idea of what's referred to as a mere equity. And that's come up in one of the previous topics as well. And then we have certain things in between. So the types of interests, or the types of entitlements, if I can use that sort of phrase, that equity identifies, changes. Just on the issue about estoppel, and thanks for that, Kelly, in terms of thoughts of wanting to do some more work on that. I might just suggest for anyone that's interested that Ben McFarlane's material, he is a law professor currently. I think he's at London School of Economics, and he's done quite a bit in this area. He's a property law expert, one would call him that. And he has written also about estoppel and proprietary estoppel in the English context. So you can have a look online for Ben's work. He's done quite a lot, written a few books and so on and so forth. But remember that he's writing from the English context, but he does make reference to Walton Stores and how the law has evolved in the Australian situation. Yeah, okay. Good. Robin, did you have any thoughts?
Yeah, mine was just basically the voluntary gift transactions. I got a much better understanding of that and how the cases are working together. Yeah, with that was my main point.
Thank you for that. That's very much appreciated. You know, as ever, I go back, I suppose, to the point that I started with, and that is this idea of wood from the tree, wood from the forest, in a sense. You know, that metaphor, you have to, in law, you have to see the delineated nuances of how the principles and the rules have evolved over time. I think it's very important to get a clear grasp of this difference between common law rules on the one hand and equitable principles on the other. What is the intervention of legislation? So we've seen, for example, that today the statute of frauds requirements, which is the historical background for why we have writing requirements in terms of interest in land, is captured through the current Property Law Act, Queensland, so the role of legislation. And how all of this sort of fits together as the puzzle that helps us to better understand the nature of proprietary interests and why they're important and valuable. And in particular, as we start coming towards the conclusion of this course and preparing ourselves for land law, our thinking about the significance of land and all the various ways in which transactions involving interests in land can take place and are recognised. I think that's very important. And then also this other last idea that, you know, those clear demarcations between areas of law which historically were important we are seeing a breakdown, in my view, of those, clear compartments of law, and more of a concern for the issues of substance that are at stake at the end of the day, and that other things must work in the interests of that. And that's where the law must be focused. Ultimately, when you're out there in practice, of course, all of this matrix of principle and rules and so forth may recede a bit into the background in terms of the day-to-day workings of the law. But when that client is sitting in front of you, you have to ask yourself, what is their issue? What is their dispute? What is the problem they're having as a matter of substance? What is the real concern or the real nature of what they're in dispute about, for example? That will help to direct you towards and help you to help your client move towards an effective resolution of why they're in dispute in the first place, rather than getting caught up in all of the formality aspects of a legal process, which ultimately you may need to embrace aspects of that, of course, but you keep focusing on the heartland of why the client is sitting in front of you with this problem which can't seem to be resolved, okay? And they need your assistance. And you're there to be their very willing and able assistant to resolve the issues that they have of whatever nature they might be. Okay. Thank you, people. I'll call it time there, and thanks for joining. Look, just a couple of administration matters before I sign off. One is I should have the second quiz by toward the end of next week, I'd say, and have that finalised then. I'm hoping to have your class participation marks sort of finalised by then too. I've got another deadline I've got to meet by Friday, but I'm going to do my best. Oh, yes, and the small matter of the final exam. I've already posted some information on that so that it's going to be available in the time window between the 28th and the 30th of the month, of May. And I've tried to accommodate what people have said to me before in terms of when the second quiz was open and so on. I hope that meets most people's, expectations. And I'll be posting up some more details about the final exam, but I'll just say now that the exam will cover those topics that were not covered in the earlier assessment tasks. So basically topics 7, 8, 9, 10 and 11. 7, let's repeat that, the exam will cover topics 7, 8, 9, 10 and 11, and there will be a mixture of problem-solving questions and essay type questions. I'll give you some more formal advice about that shortly. And also, so that's what I want to say about the exam just at the moment. Okay.
Sorry, you were breaking up there a little bit. Did you say that the exam was going to cover topics 7 to 11?
I did, yes. It will cover topics 7, 8, 9, 10 and 11, because if you've been looking at what we've been assessing up until now, we haven't assessed those topics, apart from, class participation, of course, ran through to week 9, but the quizzes, as you recall, only assessed up to week 6. So, yeah. And, there won't be, look, the other thing is I haven't fully resolved this, but there won't be a huge number of questions. It'll tend to be a smaller number of questions that you need to, get your head around and spend some time with. Let me put it like that, okay? But there will be problem-solving questions on the final, absolutely essential, because we need to make sure you've got those skills. We've done some of those in the quizzes already. The other thing I wanted to mention too is that, I'll give you a schedule for the remaining tutorials. They'll probably run into week 12, but there will be definitely a tutorial and exam preparation class, okay? And that will focus on just a general, perspective in terms of the skills that I think are important. But I think what I'll also incorporate is a practice type exam question for you to do sight unseen in the class. So I'll think about how best to do that. But in other words, I want to try and simulate the exam experience for you in class time, in a way, a little bit. But I'll think about that, and even happy to get some some thoughts on that for the exam preparation tutorial, which will probably happen at the end of week 12. That's what I'm thinking at the moment, which will then give you basically about the weekend and the first half of the review week before you actually get the exam questions, and then you'll have Wednesday night, Thursday night, and they'll be due on Friday night, May the 30th. Yep. Okay, that's all the admin I wanted to address at the moment. Okay, bye for now, people.
Thank you.
Bye. Thank you.
See ya. Bye.
Thank you.